Hello, my name is Harry Bradford, and this is my iMovie presentation for the module QXL 4426, Vulnerability and the Law, as part of the Forensic Linguistics MSc at Bangor University. This presentation is focused on interviewing and accommodating child witnesses within the judicial system. To begin with, I am going to look at some of the common and existing myths regarding child witnesses who are over the age of 8 years old, and then show how these common misconceptions can lead to the mistreatment within the system. After analysing these myths, I will then deconstruct them and reveal the reality of the situation before showing how research in the field is helping to change the system to make it more accommodating. To conclude, I will demonstrate how the field needs to further develop and improve to become more successful in its dealing with vulnerable witnesses. The term vulnerable witness is one that will be used frequently in this presentation, so it is important to define it early on. Within England and Wales, a vulnerable witness is an individual who is below the age of 17, though it can also include any individual with a mental disorder, a physical disability or disorder, or an individual with a significant impairment of their intelligence or their social functions. For this presentation, I shall focus on one aspect of vulnerability, namely children and young adults over the age of 8 years old. Within England and Wales, vulnerable witnesses may be eligible for special compensations within courts. These special compensations can include the removal of some formalities, such as wigs and gowns, or the introduction of intermediaries for the witness. More commonly, screens are used to visually and physically separate the vulnerable witness from the accused. One of the main problems with how vulnerable witnesses are treated can be traced directly back to their title itself. Simply by calling a witness vulnerable, the court is loading doubt upon the witness and discrediting their abilities to testify. And this is the main myth that must be broken down. Vulnerable witnesses are not necessarily unreliable. The myths for vulnerable witnesses include the misconception that children are easily manipulated and have a lack of understanding for the adult situations they might find themselves in. Further misconceptions include the theory that children lack the communicative skills to correctly communicate, and a feeling that if asked about abuse, a child will greatly exaggerate the claims or even make false accusations. The last myth is that following repeated interviews, therapists or indeed the police can easily implant false memories which can lead to false accusations amongst children of any age. All of these myths lead to a belief that vulnerable witnesses are unreliable. In a world constructed for seeking the truth, unreliability is not acceptable, and thus, on occasion, the vulnerable witness's testimony may carry little or no weight. These myths are far from harmless and can lead to the mistreatment of vulnerable witnesses. As Kingston and Penhill stated in their 1995 analysis of family violence, as recently as the 1970s, the term battered babies was used to describe any abused minor. This horrific shorthand shows the lack of understanding regarding the field and insufficient support present for vulnerable witnesses. Luckily, attitudes have changed, and a higher level of education has become present since this. However, the situation is still far from perfect. Misunderstanding the myths stated previously in this presentation can lead to one of two alternatives. The first is that the child witness is treated with the right intentions but the wrong methods. This can include the use of loaded questions. Loaded questions can include simply asking, "Did he touch you?" Although this may not seem biased, the emphasis is towards physical contact occurring, so to deny it would be a negative. Young children especially will attempt to please the adult, which in this case is the interviewer. Because of this, they will always try and remain positive. The interviewer may feel they are being helpful by offering the answer, however vulnerable witnesses may not divulge further information as they assume the interviewer already knows. Further, if the interviewer offers the incorrect loaded question, then the vulnerable witness may feel they have miscommunicated and will shut down communication for fear of making further mistakes. This is a prime example of the right intentions but the wrong methods. A further example of this is if the interviewer attempts to bribe the child with an alternative. This may not be as malicious as it sounds. For example, if you finish these questions, we get to finish early. The emphasis for the vulnerable witness is now to please the interviewer, perhaps at the sacrifice of an accurate testimony. The second alternative is that the myths lead to a vulnerable witness being simply discredited as they are seen to be unreliable and therefore not to be trusted. The reality of a situation compared to the myths shows a huge difference. Contrary to popular belief, children aged 10 and over are generally no more suggestible than adults with regard to their testimonies. The myth that child witnesses can't communicate is discredited by discourse analysis, which shows us that by the time a child is 8 years old, they have acquired many of the communicative skills needed for adult communication. In regards to the myth that children make false accusations, an American study showed that child witnesses with sexually transmitted infections still denied sexual assault, despite the assailant having confessed. If anything, young adults are prudish among new company and are worried of social repercussions due to their complex social hierarchy. For these reasons, they are unlikely to make up stories or have their words twisted by police or therapists. Teenagers especially crave maturity and respect and wish to be treated with both, not ignored and felt to be out of the loop. There has been great criticism of the police handling of witnesses. In Tim Newburn's Handbook of Policing, from as recently as 2004, there were calls that there should be a greater support for witnesses. He stated that in modern policing, the victims are seen as mere supporters of evidence and that sympathy is only given at an institutional level for cooperation. This reality shows the level of work that is still left to be done. So if this is the current reality, what can be done to improve the situation? The most important step is in the education of those who may come into professional contact with vulnerable witnesses. The public and professionals need to be aware of the limitations the vulnerable witnesses have, however must also be aware of their capabilities. Basically, within ambiguity there is the potential for mistreatment. It would be safer and more successful if those involved in judicial process knew as much as possible about the communicative skills and capabilities of the vulnerable witnesses in front of them. In regards to interviewing vulnerable witnesses, it is said that there is no such thing as a perfect interview. The interviewer must strive to avoid using loaded questions or accidentally bribe the victim into giving answers. The trick is to allow the witness to communicate with open-ended questions, which are proven to give fuller answers. Only when the interviewers are fully educated in questioning vulnerable witnesses can we hope to achieve a higher grade of testimony with less stress upon the witness. Thank you for watching this presentation. All references are following on the next slide.